Well, I'm really excited to talk about the title commitment today because this is one of the most overlooked contingencies of the contract as a disclosure item. How many days does a buyer have to review this with the opportunity of cancellation once received?
Cancellation once received.
So if you receive this as the buyer, how many days as the buyer do you have to review this?
Everything's 3 or 5 days, and 3 seems too short, so I think 5.
Yep, 5 days.
I'm not sure within the inspection period, that's longer.
You have
don't get
5.
that.
So the big thing, I like that you brought that up, Buzz, because the big thing, agents like to blend contingencies together. And what we need to do is remove them from being together and look at them all separately. So yeah, if you get it on day 3, some miracle way, then obviously you have any reason that you could cancel based on the property, or your buyer could cancel up until that end of the buyer's inspection date, right? The inspection period date. However, we need to separate all the contingencies out. This on its own has 5 days once received by the buyer. It's so important to be in good communications with the escrow officer to make sure that you're on that email that goes to the buyer. So you could say, hey, did you look at your title commitment? Because a lot of people always go back to due diligence. And honestly, you typically don't have this until day 5 or 6 of the contract process. So just remember, this has nothing to do with the buyer's inspection notice. This is fully to do with the title commitment itself. But I like your concept on that. Yeah, if you got a day 3, you're golden. If you keep your mouth shut, you better come up with a good reason per line, section 6A of the contract, if your buyer decides to pull out, right? The other rule set is that you should always ask more questions before canceling based on the commitment, because there has been some debate, even though the contract says very bluntly that our buyers have the right to disapprove of anything in the commitment and cancel. There is some debate sometimes if the escrow company is not acting as a neutral third party of, oh, was that valid to cancel on that? So make sure that if you have issues, you let the office know right away so we can help take care of you. And with that, Julia has been so kind from Rock Title, and here's Art, and where did Lynn go? And there's Lynn, to go over a commitment for title insurance with scary things that we should look out for.
So first off, when we send this out, when we get the title commitment, we abstract it, we go through it. My assistant Marie sends out the title commitment. So she'll send the buyer and their agent the title commitment, but she's abstracted the requirements section. Okay, and then same with, she'll send out to the listing side and she'll do the same thing, explaining the different requirements and what's needed and bringing stuff to your attention. So with that being said, I'm going to go through, because sometimes we'll send one out and she'll do the, the breakdown, kind of raising flags, and then we're like, I don't see any response. And she copies me. So I'm like, okay, I didn't see any response. So then I'll call the agent, and I just want to make sure that you saw and you read what Marie said. Houston, we have a problem, so, or a lot of times I'll call before she sends it out so that their client isn't freaked out if there's some ugly stuff on it. So I took a title commitment, and then I took some pages of some other ugly ones to get like the ugliest one we could find. So the first 3 pages of the title commitment is standard boilerplate. The first page, pretty much says, we have to, obviously they have to close the sale. We're going to issue it has the basis of the title commitment. On page 2, it has some basic definitions and limitations of liability on it. Explains, the different sections of the title report. And then liabilities and arbitration. Okay, so that's standard. This is standard boilerplate on the first 3 pages of every title commitment that we send out. Then we get to Schedule A. Okay, so the first thing on Schedule A is the commitment date. So today could be March 1st, and I just got the report and I'm sending out, and it has committed date, and it has a date at 8 a.m. And what that is when we produce a title commitment, it's with data from that has been that we can access. So this report might have been generated on March 1st, but the date down that was available for doing it was as of February 24th at 8 a.m. So I've had agents where, wait, you're just sending me this and it's been done for date. No, that is the date that the data is based on. So that's as far back in records for the county that we could access at the time the report was generated. When we go to record, the morning of recording, we do what's called a date down. And that's where they'll take what the latest on here is and go to the county and confirm that there's nothing between that date and the current date that we need to know about. If we have a title report, an order that's been open for quite a while, or it's one that I have one that's October close date. Obviously, when it gets closer, we'll do a date down. So there's a difference in updating a title commitment, might be changing the buyer's name, the seller, whatever, but doing a date down is checking to see, is there any more current data available? Okay. Generally, a lender will expire a title report in 30 days. A lot of times they'll ask, they know we date down at closing. Okay.
May I interrupt you for 5 seconds? I need you all to write that word down, date down. This is one of the most important things to know as a practitioner, that it is standard of practice and requirement for insurance to do a date down on the day of recording. There are things that sometimes come up that will stand in the way based on the date down report. In our office specifically, we had this happen. And what happened is that the lady was going through a divorce like years before, and she hid her property from the divorce decree. And guess who found it? The divorce lawyers that were after money. And she called me yelling that our realtor allowed the escrow company to repull. And now they were demanding that she paid this lien, and she refused to. AKA she committed fraud. But yeah, that's 7 elements. And that. So I had to, and then to boot it all off, the whole time she's yelling at me in English. She's done everything in English. She then goes into telling me that she didn't understand anything she's ever signed because English was not her primary language. And so every which way not to pay, and this lien, and blaming the agent for allowing the date down report, which is a requirement and a standard of practice. So if you're going to practice properly, learn this, because I kept calling it a title up report because I just felt like title's up.
Yeah. No,
But it's actually called
a
date down report. And it's something to also have that knowledge base when you're taking a listing of, do you have any liens that you know of against you at this time, or anything that you might be outstanding with? Because it's going to come out, and I want to make sure that we are in front of it instead of being reactive to it. Not saying that you should have any, but if something did come up, is there anything you could think of, including child support? So there's a lot that can hold things up if they're in back at arrears on, and we always want to make sure that we're supporting our escrow officers to be able to close their deals.
It's one of the good reasons where if somebody says, you know what, I'm really not sure, we open pre-orders all the time. So if you have a listing, have us open a pre-order. We open a pre-order, we give you the verbiage to put in the MLS, which helps us to with a discount, that helps us keep it if it goes through, so our work isn't for nothing. But that way, if something comes up, we have a chance that we can deal with it and we can get it cleaned up. If you have IRS liens, we have to get the paperwork, we have to have it hand signed, we have to send it in, and then it's a hard 15 days. So if you want to have more flexibility with your listing, be able to take an awesome cash 2-day close, you have to have a clean title. And so if you do a pre-order, we can see ahead of time if there's anything that needs to be cleaned up. So if there's any opportunity or you just have a sense that there might be something that's going to pop up, let's deal with it ahead of time. It just makes it so much smoother. And then if we've already cleaned it up, it just helps you fight to keep it with us or whatever title company you're using. I just assume y'all want to use us. So, okay, so the next part here, item number 2. So we're on page 4 of 12. We're on Schedule A, and so item 2 is the policies that we're planning on issuing. So in this case, the first one is the insured parties are going to be this is the buyers that are going to be insured on the owner's policy, and then the second item is the lender that's going to be covered on the loan policy. So obviously the proposed insured amount for the owner's policy is the loan amount. and, excuse me, is the sales price. And on the loan policy, it is the loan amount. But you do have occasionally some lenders that will require 125% coverage, which, so the lenders have in a hard money situation where they will request for coverage higher. So in that circumstance, the proposed policy, the coverage amount is going to be higher than the actual loan amount is because they've asked for additional coverage. Just like if we're doing a reverse mortgage has a loan amount, but it also has a max claim amount, which has absolutely nothing to do with the loan amount. So you'll see a proposed, so that's the amount of coverage that we're issuing to, not necessarily the loan, most often the loan amount, but in the case of a lender requiring additional coverage or reverse mortgage with a max claim, that amount would be different. So then we've got, following down on 2, or actually that should be number 3, which that's what I get for cutting and pasting reports together. Item number 3 shows that this is fee simple. So if you look at the bottom, fee simple is the owner's property rights are indefinite and can be freely transferred. The other option on there would be lease. So if it was leased land, then obviously they can't just transfer it on their own. It has a lease. And so there's other parties that have to approve it. I've done lease Indian land, which is tons of fun because everybody and their brother has to sign off before you can do the transfer. So if you,
We have a lot of leased land here.
Yeah, we have lots
Yeah.
of leasehold.
Mostly owned by the Herbergers and the Gamages, but.
Yeah.
Yeah,
So-
yeah, when they're Indian lease land, it's a little bit longer process to get it the transfer approved, but if they're other companies, yeah. Okay, so then we have the vested. So this is how the current title is vested or how we're acknowledging it. And what I mean by that is sometimes you'll have a deed that wasn't done correct and the county's not observing it. And so you might have a deed that was recorded, but the county has not accepted it because of God knows why, which is a whole science project in itself. So this is as of our records and what the county's acknowledging how the owner of record is reading. Okay, so on your title commitment, on your purchase contract, this here has a community property with right of survivorship. So if one of them is deceased and you're only working, if your seller that you're doing your listing is just Johnny, then you need to ask, well, where's Jessica? Because there's either a divorce decree or she might be deceased or she might have been deemed incompetent, just whatever. So we need to understand if the current ownership is showing multiple parties, where's the other party? With the community property with right of survivorship. I did a pre-order last year for somebody. They were looking for judgments and liens. We got it in and I looked and I said, oh yeah, no, it's clean. There's no judgments or liens and everything. She said, okay, great. I didn't check the vesting and I didn't point out the vesting. It had just husband and wife. He had gone into hospice and died. So then we had probate, which if I had known that they were listing the house because of a probate, I would have paid more attention to the vesting. So another thing with the pre-order, it also will help show you the vesting, because in this case, he was still alive and he was competent until he died. He died of cancer. So we could have done a warranty deed and added an acceptance on to add the community property with right of survivorship, but there was no judgments or liens, but I didn't realize that they were selling because he was in hospice. So I asked a lot of questions when we were doing them, and we really try and point out on the vesting. So it's real important to understand who's got the right on the listing, who shows owner of record and where is the other party.
If it's in a trust, then you don't have that probate issue, is that right?
Correct. If it's in a trust, we don't have that probate issue.
Okay.
Correct. Now, if we have a probate, okay, so let's say, like I have one right now that had John Mung, okay, and he owns some land, and it just had John Mung. Well, John Mung's deceased. Oh, but we have a letter of representation. So I have gotten to where I say, okay, well, I need it up front. Because it's from a North Dakota probate court.
Yeah, exactly.
Okay, so you don't have to go through a new probate, but it has to be filed here. So they have to get an original copy, certified copy from whatever state the probate is in, and it has to be filed and assigned a an Arizona probate number. So that is the letter of authority. So it's where Arizona probate says, yes, we've looked at the out-of-state probate and we agree that these are the people. So here I had a sales contract that only had one person on it. When I got the letter of probate, there's two co-representatives. So now I had to go back and, well, the other representative has to sign the contract too, because it says it says that they both have to act on everything. So it's better for you up front to understand who all has to sign. The sister was not too thrilled. I'm on vacation. I'm out of state. I'm like, we're supposed to be closing. And so I had to send a notary to sign a purchase contract because she's like, I'm on vacation. I don't have a printer. I don't feel like dealing with this. I'm like, but I really need it. And so I had to send a notary to take a purchase contract with the authority from the agent to get it signed because she wouldn't DocuSign. She wouldn't. Anyway, so you're better off knowing who is of record and who's currently alive and in what capacity they're going to be signing.
Well, that comes up also with the trust,
Mhm.
because title will need documents of that trust. They may not need the entire thing, but they do need to know who is the signer, because sometimes it's one and sometimes it's multiple people.
And usually if I can get multiple, I'll have multiple. So, and on a trust. So if you have a trust that is the John Doe and Jane Doe trust, and John Doe and Jane Doe sign my purchase contract, then I can have them sign a certificate, a trust certificate out of our docs, which states that it's where they're swearing that as of right now, they still have control of the trust. They haven't resigned. They haven't been deemed incompetent. They're, and so we'll have that signed. But if it's just the family trust, with a name, we don't know if it's one that they got and there's really 4 other siblings. I've seen, you'll see in a trust when we're looking at the authority, sometimes there'll be multiple. I've had 4 that all were co-trustees and they all 4 had to sign, but more often it's sequential. So it goes 1, and if they die or resign, then it goes to the next, and then it goes to the next. But the funds are all paid to the trust, and then they split them up after. But again, it's knowing who your party is and making sure that they're authorized. And if you have a question on your listing, call me and I can pull up and we can see, and I can help. You're like, okay, I'm doing this, I'm listing, and I'm showing in Monsoon, this is the owner, and I've got this person in front of me saying, then I can pull up and see, and then we can figure out what questions or documentation we need to bridge the authority. So. Okay, so then we've got item 5, which just shows the
Land described.
that we're going to describe the land in Exhibit A, which is farther in our report. Okay, so Schedule B, B Part 1 are the requirements. So this is the main meat of what we're going to need. And so we're on page 5 of 12. And so the first 3 items are like a given. The first one here is that the proposed insured, that all the requirements and stuff have to be met in the interest. Item 2 is, they have to proceed with the sale. So if they don't agree and with, if they don't execute the sale, okay, and pay the amount for transferring the interest, then obviously we're not insuring the transfer of interest. Okay, and then obviously they have to pay the premiums associated with the policy. Okay, so that's obviously if they don't close the transaction and if they don't pay the premiums, then we don't issue any coverage. Okay, item 4 is always the property taxes. And so we always check these quite often. Like right now we're in tax season. And so a lot of the reports when we first did them showed that the second half hadn't been paid because a lot of the lenders don't pay until like April. And so we're updating the tax stacks and stuff. So we'll update it. We won't update the title report for it, but we go in and manually check with the county before we close and make sure that the taxes are paid current. And then we'll end up paying the tax. So right now is every day I get probably each week I'm getting a couple of return checks from the tax, from the county. Because what happens is when we end up in that gray period where taxes are due, they don't show posted yet, I have to pay them. And if they're not paid by May 1st, then there's interest and penalties. So I pay them, the lender paid them, but they hadn't posted yet. Whichever one arrives at the county second gets returned to whoever sent it. So I'll get the tax check back and it says that they've already been paid. So then I receipt it in, and then I usually call out to the agent to ask them, do you want to have a reason to contact your client to be a hero and tell them that I'm going to be sending a buddy? Or sometimes they'll go, I'm busy, just call them yourself. But that way it's,
Bad
you know,
agent.
I know, but it's like, hey, I'm giving you a reason to call and be a hero. Hey, I just wanted to, call and let you know I have a check for $1,469 that I'm going to be sending out to your client. Do you want to call and let them know that it is coming, it is real, it is valid, please cash it so I can close out my file. But if you don't want to call, I'll call. I'll be the hero, I don't care.
Do you usually have credit for buyers
Have credit for
or
buyers.
sending them a check? Because I thought usually you would collect more than, so you didn't have to go back and ask them for more money.
Oh, padding files, usually because now we have the final closing disclosure. Usually the only thing that I'm refunding at closing is one, if we ended up closing a day or so later, and then there's more tax credit proration. So then they'll end up with a little bitty check that I have to beg them, could you please just deposit on your phone?
Yeah.
Please, I know it's $2.53, but could you, I don't expect you to drive the bank, but please clear it so that I can close out my account, my file. But, we don't pad them, but what we do end up doing is, because at the end, sometimes it's wonky and we don't know exactly when we're getting loan docs, and we don't know if I'm going to get them that morning or the day before, or what date they're going to be dated. I'm begging, I won't take the notary fee off until I really know we're not going to need it. Because if I take it off and the lender discloses without it, I can't add it back in. And I'm not paying the notary. Yeah. It's like they have to be paid and they don't work for free. So I'll have agents adamant, oh, but they're going to come into your office and sign. Okay, well, when that day comes and they sign, when I close out, I'll take it off. But if I take it off now, I can't put it back on. Or you're paying it because we can't charge it to the buyer. So, so once in a while, they'll just be adamant they want it off. I go, okay, well, I'm going to shoot you an email and you need to respond confirming that you're aware it's coming out of your commission. If I have to add it back on, you're paying it. So, okay. So then we have item 5. Item 5, if we have an HOA or 1 or 2 or 3, they'll each be listed out separate. And so this is that we have to confirm that everything is all paid current, and that we get a demand from them. We order the HOA. The HOAs do not send us, once in a while, we'll, depending on the management company, we'll have access to the disclosure docs. Most often, they'll send us the demand and a couple forms if they want a couple forms signed. They don't send us the whole disclosure thing because they don't want us to keep it for another file because they're so expensive. It's $400 usually to send out PDFs that they've had around forever. So the
Right.
so when we start on here, you may want to let your buyers know that they'll either get an email, or if it's like Colby Management, they'll actually mail them a box with a pretty picture on the top, with their disclosure and stuff in it. But I don't get, once in a while, some will send me an email stating that they've sent the disclosures out, and I'll forward it to the agent so that the agent knows to tell their buyer to go look for it because they've got due diligence on the HOA stuff. But a lot of them, they'll just send the demand. And so usually the demand will come in and we'll just confirm that we got the demand and it's clear. And usually they've sent them the same time, but sometimes they don't. A lot of the management companies purposely won't send us the demand for 10 days because if we want it sooner, they want to charge through the nose for a rush fee, $100, $50. And so they'll send the disclosures out right away, but they won't send us the demand until like day 10 unless we throw more money at them. Okay, so the next item on here is item number 6. So item 6, I've attached a copy for you, or I've given you a separate copy. This is an owner's affidavit, okay? So last month when I went through with some of you with the coverages on our title commitments and stuff, one of the things that we talked about was indemnifying and stuff. And so when we close a transaction, we have them sign, the seller sign an owner's affidavit. This is one of the owner's affidavit. And so this is where they're stating that all the taxes and assessments are paid current. There's no special taxes or assessments they've been notified about. They're, same with the HOA, I had one years ago that they knew that they had just approved it was like a $1,900 assessment for slope maintenance or engineering that had to be done. Each parcel had a $1,900 special assessment they had just passed, but they said, oh, no, we don't know anything about that. But yet they had notices. But when the demand came over, there was no reference to it on there. And so obviously when the buyer found out they had a $1,900 bill due the month after they closed, they were a little peeved. So this, by the seller signing this affidavit that none of these, they haven't done improvements, land or construction in the last 6 months. They don't have any pending repairs or improvement adjacent, on the streets. So they haven't been notified. They haven't done any building on here without permits. They haven't been notified of any zoning violations, so this is pretty much their signing and swearing, that that there's no tenants left behind, there's no open leases. So this is where they're swearing to us that we're not going to have the buyer coming back pissed on any of these things and want to file a claim. So if they lie on here, and there really is improvements that were done and there's zoning violations or whatever, any of these, we cover the buyer and we go after the seller. Just say it. So when they swear on this, which is part of why we control the notaries, we're ensuring it. We want to make sure that the notary or the service knows that they don't just say, sign here, that they make them read it and make sure that they know that this is an indemnity agreement. If they sign this and lied about anything and there's a claim filed from the buyer, we are coming back for restitution from them. We'll cover the buyer, but we're not going to eat it.
I think it was happening a lot with the painting of the house. There were, HOA was requiring for them to paint the house and they weren't disclosing it.
Yeah, see, when we get in an HOA demand, it'll say that there's a violation right on it. And shame on the escrow officer that didn't point that out, because we'll call the listing agent right away and just say, hey, got the HOA demand in, it shows the house has to be painted. Are you aware of that? They'll go, oh yeah, no, they just painted it. I'm like, okay, great. Because sometimes, or we'll have one for comes in with weeds and all this stuff. And it's like, well, yeah, we cleaned it up to list it, but the HOA hadn't gone back out since they issued the violation. So a lot of times the violation has been cleared already, but we have to check. And then we'll contact the HOA and say, oh, we've been told this violation is clear. Can you have it re-inspected and cleared? If it's one on paint or different things and they decide between the two parties, okay, the buyer is going to accept it. I just had one that came up where the seller went ahead and gave the buyer a $3,500 credit to take responsibility for it. I drafted an amendment that I had read, that had the buyer sign at closing that they agreed to close with the open HOA violation for paint. But we also find out from the HOA, and we put it right on that addendum form, that the HOA gave until X date or so many days after closing, or how much time they gave them, because it isn't where you're just assuming responsibility. We'll give them clear, they gave you till the end of the year to paint it, or they gave you until October 3rd or whatever date to pay it. Otherwise, they're going to start fining. So that way the buyer's aware that they're closing with that open violation, they're taking responsibility for the violation, but they know how much grace period they have until they start getting fined for the violation.
Question for you guys. What part of the contractual contract, if it has an HOA, gives the buyer the ability to renegotiate based on HOA violations?
the HOA addendum.
What page?
Mm,
Yes.
Second page.
Thank you. Yeah, page 2 of the HOA addendum. This is not a change in disclosures. This all falls under the changes as listed on page 2, which also allows them to cancel based on the CCNRs and the financials. So anything to do with the HOA, always go to the HOA addendum. I just want to make sure we're good. And how many days do they have to review this in?
5.
5. Yep.
Yeah.
3, 5, or 10.
3, 5, 10, yeah.
My favorite one is on the HOA addendum, they'll mark that disclosure fee, they'll put it under transfer, and then on page 3, they'll put that the buyer's paying the transfer fee. Well, if you read page 2, it says by Arizona law, the seller has to pay the disclosure fee. So you can call it on page 1, whatever the hell you want, but when the demand comes over and says it's a disclosure fee, it's going on the seller's side. So putting it under transfer at the top, oh, it's $400 to transfer and the buyer agreed to pay it. It's a disclosure fee. Arizona law requires the seller to pay it. So I don't care where you put it on page 1. Page 2 says I'm supposed to put it on the seller side. So I get that all the time. Oh, but they marked that they would pay it on page 1. It's not negotiable in Arizona. The disclosure fees have to be paid by the seller.
Well, then you have the agent that says that she worked with title to make sure it gets billed that way. That the seller, the buyer is paying the seller's disclosure fee, and that's how they set it up. And I'm like, you did what? And title's doing that?
Yeah.
Oh yeah, they do it all the time for me. And I'm like,
Okay, they should be fine. They should be the one to hit get the violation because they know better. Yeah.
And that would be all under the Arizona Department of Insurance. And they have a risk management money, like we have our funds. I can't think of the name of it right now. They do too. And if
Recovery.
somebody feels, thank you. I was like, it's this word, it's out there. It means when the public's harmed, we don't make the claim for the client because our client relationships over at closing, but you can always direct them to contact the Department of Insurance and they can say, I was harmed.
so the key is when you're talking to your buyers or sellers, if they're calling the HOA like they're supposed to, that they ask, what are the fees? And HOAs are sloppy and they'll say the disclosure and transfer fees are, and give you one amount. It's like, thank you, but I need to know what the disclosure fee is and what the transfer fee is. The transfer is negotiable, the disclosure is not. But that's where this agent had gotten her title company, that they just bundled it and they billed it all to the buyer. Like, no, it's not bundled. There are 2 fees.
Yeah.
Or sometimes they're 5 or 6.
Well,
Sometimes
yeah,
I
yeah,
get
yeah,
these
yeah.
and I'm like, seriously? Like, okay. The
No, transfer. Disclosure is required by the state. to be provided.
cool, okay. What time are we at?
We're 10:30.
Okay, so I have like
You got
15
30 more
or
minutes.
30 minutes. Okay.
You're good.
Okay, so item number 7 on here is that there's a recorded deed of trust. Okay, and I don't know how many of you are familiar with MERS. Okay, you'll see where it has the beneficiary here and it lists mortgage electronic registration services.
Mhm.
We joke, that's where's Waldo. Okay, because if you have a Fannie Freddie compliant loan that is able to be sold on the secondary market, they register it. So on page 1 of the deed of trust, there's a 16-digit number. And there's actually a website called MERS that you can go in and you put in that long number and it'll give you the lender where it's at now. Because sometimes they're sold, they're transferred. I had one that somebody passed away and the heirs were trying to coordinate and trying to figure out where the mortgage was. And because this is when it closed, who had it, but that MERS servicing, they track who currently has it. So that we were able to go in and look and see where Waldo was. Okay.
And that's good to know too, because like your clients' loans are typically sold within the first 2 months.
Mhm,
If they're gonna be with a brokerage that sells their notes. So it's
mhm.
kind of cool to be able to like direct them there.
Yeah, it's like
That's kinda
where-
cool.
Yeah.
One more plus for you.
Yeah. Well, or we'll look and we'll see it and they're like, oh, we want to do a quick close and can we close in a week? Well, if it's one that you have to do a handwritten authorization and you have to send it in and they're 5 to 7 on getting a payoff. So a lot of times it depends on who the payoff lender is. It's a one that has the automated system. So a lot of times we'll hop on MERS just to see who has it now so that we can give a better expectation of if I'm gonna need 5 days just to get the payoff demand, or whether I can get it in a half hour. And so we'll look to see where it's at, just so we don't stick our feet in our mouth. So. Okay, so then we have item number 8 on here is the beneficiary is Arizona Additional Development Authority. That's usually a down payment assistance. And so we'll pull them up. A lot of times the title will have it on here, but it might be that if you own the property for 3 years or 5 years, it automatically expires or it's automatically forgiven. And so we'll go ahead and if you click on, see where it says it has the 2019, if these weren't in black and white, that would be blue. So when we email it to you, anything that is blue, if you click on it, it will actually open the document. They're hyperlinks to the actual document. So in this case, I would click on that and I would see, is this one already forgiven? This is from 2019. Is it one that was a 3-year and it's forgiven? Because if so, we'll still follow up and get it, make sure that they record a release, just so it doesn't hang out there in limbo land. But there wouldn't be any payment due on it. Sometimes there'll be where if it's a refinance, they won't let you refinance without paying it if you're within that period. Next one we have is UCC termination. Okay, so you know that we have to okay, UCC filings are not always solar. Okay, sometimes they're heat pump. I've seen them for other things. Most often they're solar, but not always. Okay, and we have to look, see, like here, this one here has a secured party. So sometimes a UCC filing is because we have a solar lease that says the stuff I have bolted on your roof belonged to me and that you agreed. Okay, other times it's a loan. Okay, and a loan, we're going to have to, if it's going to have to be paid off, or if it's assumed, they're going to have to qualify for it. And we're going to have to do a subordination, because most of the lenders won't give us a termination because it's really not paid off. So we'll have to do a subordination instead of a termination. So that's why I hate even the new solar addendum still doesn't tell me diddly squat on what I'm doing. We get the solar addendum. The solar addendum doesn't tell me if it's a lease or if it's owned, it doesn't tell me anything. And just because solar is on there, if it's owned, I need to know if there's a warranty that's still valid that I need to transfer. Because if you buy a property and they say, oh yeah, it has I bought it I bought the solar 5 years ago and it has a 25-year warranty on it. But if no one gives us the information to transfer that warranty, yeah, even if it's free and clear, we still got to transfer the warranty. But if I don't know and nobody, so I added a whole solar section to our seller's opening package. But again, if they don't fill them out and send them back, I'm still in the dark.
We have access to a seller information sheet if we're taking a listing.
Mhm.
You guys don't have that, ask Mandy, because she's got
Oh,
that.
we have one.
more-
Yeah, we have one
so-
where they put in, because I also do a lot of that's got irrigation out in Stick City and stuff. So
But that way you have the information before you put your listing up, because there's a lot of that that's really important to know.
mhm.
Can I back us up for 5
Mhm.
seconds? Because we talked about the deed of trust being paid off, and what I've commonly been seeing are people that have quit claim deeds, not quit. And it's my understanding they're not insurable, and you need to make sure that you follow that chain. Is that in here by any chance?
I think one of those, I think I probably have it
sorry.
on one of the other pages.
Okay,
Because I added more uppy stuff in here. And so, yeah, what we'll end up having is when you have we have a transfer that was done. So let's say we have a deed of trust. Well, actually, even if we don't have a deed of trust, if the last transfer was a quit claim, okay, we'll have the person that did the quit claim sign an affidavit of uninsured deed, where they're stating that they really intentionally gave up their interest in the property, that they did not just transfer it over for finance purposes, they had the crappy credit, so I came off and so that we could get it closed, or for whatever reason that they intentionally gave up their interest. A lot of times when I have somebody that wants to do a favor, as a quick claim, I'll ask them if so, I'll go ahead and draft the affidavit of uninsured deed, because it's easier to do it now when you know where that person is and when you're doing the transaction, than later down the road when you're having to go back to that ex-girlfriend and say, you know, hey, the title company wants to know if you really did give up the property. So,
Thank you for that.
okay.
Something that comes up in my life a lot.
Yeah. Okay, so how am I time-wise?
You're good. You have 20 minutes.
Okay.
You just keep going through
Okay.
so they can see it and then hit stop and end.
Okay, so then we have item number 10, which is, this is where when we see a divorce decree has already been recorded. So they may have filed, so we'll see that they filed, but a lot of times they filed for divorce, the divorce isn't final, and they're selling the house. So if that's the case, I don't have, they don't have to finalize the divorce before we close. They're each getting 50-50 of the proceeds, unless they come up with a different split, and then I have papers that they both sign that the split's gonna be 60-40 or whatever. But in a divorce situation, I'll do two, if we know that it's a 50-50 or a 60-40, I'll split the 1099s. Normally, if you're married and we close, you get one 1099. Okay, that's for whoever usually is the first filer on your, assuming you're filing jointly. If they're filing separately, or if they're going through a divorce, I'll do separate 1099s. If they choose to file together, fine, you just put them together and list them on the same return. But if they want to file separately, then they're separate. But obviously, if it's not 50-50, I need to know what the split is, and they both have to sign agreeing to whatever the different split is. And same with, I end up where a lot of times it's mother, daughter, father, you know, whatever, just, and one of them was really not participating. Their name was on it for God knows why. And so we'll close the sale, and they'll say, oh, well, no, really, all the proceeds are really my daughter's, I just signed, or all the proceeds it was really my mom's property, but I just had to co-sign and stuff for her. So really all the money. So I'll set it up where the 1099 and the proceeds go proportionate to the right people. But if no one tells me, I can't do it. So. Okay, number 11 is a judgment. So this is the state of Arizona as the creditor. So we end up having to get cleared on that. We'll have to order a demand. Now, we never just order demands and reach out to people on our own, because as soon as they know it's tied to a real estate transaction, the seller no longer has an ability to negotiate. So instead, when we get in the nasty grams on the title report, we'll send them copies of the judgments and ask them if they've already been resolved. And if so, send us the documentation that they've been resolved. A lot of times they've been resolved and they sent them the satisfaction or the release, and they didn't record it, and they just had it in a drawer somewhere. Or if they want to, we'll ask them, do they want to reach out and try and negotiate it? Because they can get a settlement letter. And if I can get a settlement letter from the creditor that they're willing to take a lesser amount, then I can go off the settlement. But as soon as I call and they know that it's tied to a real estate transaction, your negotiation just went out the window. Okay. So we'll do a custom authorization, send it to the seller, authorizing us to reach out to them so that there's no room for, I never authorized you.
So satisfaction of a judgment, the buyer or the owner of it is supposed to record it all the time?
If the creditor, if you had a judgment and you own property and you worked with the place and you paid them, and it still shows up on here, if they mailed you a judgment and you never recorded it, then you can give it to me and I can record it, and then it'll go away. Or a lot of times they'll say, pay us and we'll release it, and they never get around to releasing it. So you'll have your proof of payment, but then I still try and get a release. Otherwise it's going to haunt you forever, because it's going to keep popping up down the road. And so We try and clean it up so that it doesn't keep haunting you, not just take where your proof of payment and just leave it at that. Otherwise, next time you try and do something a couple years down the road, and the longer you kick the can down the road, the harder it is to find the company or the people or anybody. So the next one is, one of the things that we found out was Mercy Care. Whenever anybody went into the hospital, Mercy Care was automatically filing a 15,000 lien. If you went into the hospital for anything, regardless if you paid your bill or whatever, they automatically were filing a $15,000 lien against your name. Okay, a judgment. I had one that it was an agent out of the Goodyear office, that it was from when he had appendicitis when he was 15 years old. Yeah, and it's like, but then we call in and they're, oh yeah, it's zero. So they got in trouble, and I think in 2016, I think it was 16, they were no longer allowed to just automatically, you went in the hospital, you got a judgment recorded against you. They got in trouble and they can't do it anymore, but we're still finding them and still cleaning them up. So my assistant Marie has a fast track phone number where we call in and verify, and then we get the release from them. But yeah, they just went to town. Anybody that went in the hospital for anything slightly major, they just automatically filed a judgment against you.
You can also find them from Access. Will
Hmm.
file judgments against somebody that has been on Access, which is like, they probably may not be owning a property, but you never know. And they can pop up at the end saying, yeah, you were in the hospital and you didn't pay us.
Mhm.
They had no money at the time they were in the hospital,
Yeah.
but now that the house is being sold, so you have to go through and figure out what's going on and try to help get that
Yeah,
resolved.
and again, a lot of this stuff is stuff they didn't know about, and that's why you're doing the pre-order sometimes. If you're, especially if you think it's a property that's gonna sell quick, you don't want to have where you frustrate the buyer because you're all, oh yeah, we're great for a quick sale, and then we get the title and we're like, oh, science projects are us. Yeah. So the 13 and 14 here is marital status. So the only thing on there is their vesting. So it's, so if Rachel and Felicia, or Raquel and Felicia are single, unmarried, married to each other, whatever, we just need the vesting so that, and when we have what their vesting is, that'll clear the issue. If they're married to other people, then we'll need to get disclaimer deeds from the other parties. Which will coordinate that. So then we have item 15 is just recording a warranty deed from the sellers of record to the buyers. And then the 16 is if they're doing a new loan, that's just recording the new loan. Okay. On page 7, I've highlighted the corporate special warranty deed and the date. So that's under the chain of title. So this just shows, if you click on that, that's the deed that transferred the property to our sellers. Okay. One of the things I find quite often is when they buy from a new home builder and they didn't send their opening paperwork back, that's where most often where I see their husband and wife with no final vesting, because the builders, fine, I sent you your opening paperwork, you didn't send it back. I don't care if you're community property, joint tenants, whatever, no skin off my back. And so they won't. So most of the time when I just see husband and wife and no final vesting, it's usually from a builder, and it's because they never sent their opening paperwork back. Buyers, sometimes, we're hounding them. We need your paperwork so we can do your paperwork properly for down the road. So if they never specify the vesting, a lot of times they don't get it. Okay. Okay, the note will indicate here, single family residence. Sometimes it'll say, we usually just do single family residence. Sometimes we'll do planned unit development in there, but most of the time it'll be single family, or it'll be if it's a condo or if it's vacant land. And then we have the address. A lot of times people will get all worked up on the address that, oh, is it west? Is it without a west? The street sign has it with a west, but this has it without a west. We ensure the legal description, not the mailing address, just so you know. So you can call it the left side of the moon, and it's still going to be insured based on the legal description. Okay. On page 7A, Okay, on here it has a mobile home commonly known as, and this one is, it has again, the mailing address. Okay. If we look back, if we flip over to just for simplicity's sake, let's see here, I've got, if you flip back to 9B real quick, in the exceptions section, if you have one that's a mobile home, if you go back into the exception sections, you'll see the affidavit of the fixture. So this one had 2 mobile homes on it, or 2 parts. And it has the affidavit of the fixtures. One of them was recorded in 2006 and the other one was in 2021. So that would show that they're classified as real property, as long as the county really accepted those. I've had 2 in the last 2 months that had affidavit of the fixtures recorded, but then the county didn't recognize them. They had surrendered them, but then when the assessor went to do the transfer, they didn't. So we've started double checking them. I have 2 right now that, yeah, one of them, they signed the affidavit as individuals, but the property was held in their trust. And so we're having to get a bond to bridge it. And then the other one, they couldn't read one whole left side of it, but they recorded it. So we're having fun hunting that one down. So yeah, so anyways, if we flip back to 8 of 11, this is where you'll see like 10, 11, and 12. Those are 3 different associations. Okay. Hang on for 1 second. I'm just trying to get the people online caught up. Okay, yeah, so there's 3 different associations there. So you got the Sun City West, then you have the Condo Association, and then you have the Rec Center of Sun City West. So sometimes we'll have 2 or 3 different ones. Again, you've got your easements on here. If you see where the highlights are, I highlighted them in yellow, but those in your title report, if you click on those you can open. So a lot of times the CC&Rs are here in item number 16. If you want to see them or read them ahead of time, you can click on them. Okay. One of the things I've seen a lot lately is I do a lot of land out in Tonopah and Buckeye. And a lot of the big land developers have decided they want to keep the neighborhood in a certain thing. So they're recording CC&Rs. And there's no active HOA, but there's CC&Rs. And so we'll have a dispute going. It's like, oh, but the seller says there's no HOA. There is, it's an inactive one. The CC&Rs that are recorded still apply. So if they have put in the CC&Rs restrictions that exceed what the city zoning restrictions are, they apply. So I had one where he's like, he wanted to build a 1,450 square foot house, but the CC&Rs say a minimum of 1,750. And so he's like, well, why can't I build it? Because the CC&R. So in this case, when we have one come over where the seller's adamant that there's not an HOA, but there's CC&Rs, I will send the CC&Rs to the buyer and their agent and let them know the seller states that it's inactive. They aren't collecting any dues or fees, but the CC&Rs still run with the property. Okay, things that are recorded against the property still run with the property. Okay, if you have, let's see, I'm trying to think of some other ones on here. There's mineral rights. If you look on page 9A, just to confuse you, you look on 9A, there's a joint well declaration. Okay, so that's a well agreement. So if we're transferring a well, there's a well agreement, we have to figure out if the well is on the property we're selling, we have to do a transfer and report the transfer. Or if they're on a well agreement, we need to make sure that there aren't outstanding fees. Sometimes there's water, like a water utility thing, but then also there's maintenance. I had one last year that there was a $690, their part of replacing the pump was like $690 or something. They'd been having a pissing contest. Well, we couldn't close. We had to pay that $690, but if we hadn't called the well owner to check, the buyer would have been, hit with a $690 maintenance fee that was from the prior owner. But so we have the well agreements we have. There's I did some land up in Congress where there's irrigation and it's farm and agriculture, and they they did an agreement with the neighbor next door where they promised to keep their part of the canal clear because the problem was the water wasn't getting to the other lot. They had rights to the water, but if the lot in front that it had to go through, if they weren't keeping their part of the trench clean, so the water wasn't making it down through there. So they actually we had to draft an agreement where they agreed to keep it clean. They had to pay $20,000 to get the neighbor to agree to keep the trench clean. So the water would come through. But yeah, so there's different agreements and stuff that you'll see in the exceptions in the back. And if you click on them, you can open them and see what they are. Okay, and read them. So you should be familiar with the property, and that's another reason you may want to do a pre-order is so that you're familiar with any weird things with the property. Is there a well? Is there septic? Is there, water rights? Is there road maintenance agreement? Okay, if there's a road maintenance agreement, we need to make sure if there's outstanding fees that they've been paid. Okay, so then on 10 of 12, we have our legal description. And again, this is what we're ensuring is the legal description, not the situs address or the mailing address. We're doing the legal description. And then we've got page 11 and 12 are just our standard policy on privacy. It's a privacy notice. Okay. Do I have any questions? Most people, they don't even read them, to be honest with you. They'll go, what do you read? You need, I'm like, my assistant sent it on the email to you and the buyer, you and the seller. But yeah, but we'll try and raise, because we know everybody gets so many emails and people don't read anymore. They don't really. So I'll call and say, hey, we have an HOA violation for paint. Or I had one of the metal fence behind that was on the golf course side was all rotted out and rusted. So yeah, I'll call and in case you didn't read the thing we just sent you, what are we doing?
Well, there's catch-22. Not only should you be reading it, but most importantly, you should be alerting your clients that they need to be opening it and reading it because they have 5 days from the date they received it to complain about it. Not 5 days from when you tell them you saw something in it, but 5 days from when they received it. It's their responsibility to be reading it.
Well, my viewers.
No, they receive it. We send it at the same time.
It
So
goes
the
to both.
agent, yeah, the agent, we send it to both at the same time, but usually if it's something really ugly, my assistant comes in and she'll go, "Ooh," and then I'll call usually ahead of time so that the agent knows a little bit more about it ahead of time so that we don't want to have where it goes to the agent and the buyer at the same time and the buyer opens it and then calls the agent and the agent hasn't looked at it. They're like, what are you talking about? So we usually will, as just for grace, we'll try and call you first and explain it to you and kind of what some of the options are or what we're doing or what we think needs to be done so that when you're then you can initiate the call to your buyer, or if your buyer calls you, at least you're not going, I don't know what I'm supposed to do. Yeah.
But Buzz's point was as the representative when we receive it, but typically title sends it to the client, not just to us. It should be going from title directly to the buyer or the seller. But the clock starts ticking once they get it. So, and how many times do they bury it?
Yeah.
So I've got a deal, just got a condo cert demand for a HOA violation on there. It outlines a bunch of fees, right? One's like a demand fee and other fees from the HOA. Those are gonna go to the seller side, correct?
Depends on what they are and depends on what was negotiated. So the demand fee and the disclosure fee have to be charged to the seller.
Okay, because on the HOA addendum, it says any fees not otherwise disclosed in this addendum is gonna be paid by the seller. So those are,
Well, then, yeah, so
All
if if the fees weren't disclosed,
which they aren't.
then it goes to the seller side, which I love since they added that, because then it's like, you guys were supposed to get an updated, accurate one in the first place. And a lot of the associations that we do over and over again, and a lot of times they'll have where we can give you the site to go log on, like HomeWise or Condo Search, you can go on there and log in and put in the association and they'll tell you what the fees are ahead of time.
You have to pay a fee to get.
No, not for the fees, no.
What is that, condo?
Well, it depends on which one. So there's different property management companies, and then a lot of them use a service that sends out the disclosures and coordinates getting the demands in and stuff. And those ones are like condos, or there's Condo Search, there's First Serve, there's, so it really depends on which one is handling it, so.
HomeWise was the one. she was
HomeWise does a lot,
referencing.
yeah.
They do a lot.
HomeWise does a lot of them around here. HomeWise, Condo Search, and First Serve are the three biggest ones. And then periodically I had one last year that it was a little bitty 6-unit condo thing that this lady that was like 96 years old and not very capable anymore. Nobody would, nobody would, it was one of Knowles. And it's like, nobody wanted to be the property manager of this little lady. It was, everybody talked to her and everything else. She hadn't paid the insurance in like 2.5 years.
Hmm.
And it expired, and because she really shouldn't have been managing it anymore, but yeah, so. Yeah, the lender said, no, this is a non-warrantable condo because the management's questioning. Yeah.
I had one that I had to do because the HOA had a non-property. And they kept going off, so they actually foreclosed on it. The guy walked away with it still, but yeah. But he found it that she was being foreclosed on by the HOA, and so he got her to sell it and pay off and all. And she still walked away with money, but they can foreclose on it. The banks won't let that happen, because the banks won't let it, whatever stuff.
Mhm.
This is off topic kind of, but how did HOAs get so much power?
Right?
I'm gonna stop the online thing here. Okay.
Yeah.
So,
Well,
People didn't vote, so they don't have that power.
really?
well, it's
in the community?
homeowners, it's a home, most people don't realize
Most people don't
a
like
home,
them.
no, most people don't realize they are them. Okay, a homeowners association is a group of people